constant in place and time. In the absence of conclusive evidence of harmful effects, environmentalists tend to presume that such effects exist. Environmentalism is associated with certain values that emphasize acting collectively for the common good and fitting harmoniously into the natural and social environment. Environmentalists tend to favor regulation to prevent or correct the widespread harms that they see in the world. Now, this environmentalist worldview has implications for the law. It assumes serious secondary effects or externalities from environmental disturbances, even though those effects may be uncertain or difficult to measure, and thus it supports steps to control those externalities. And you have Supreme Court justices that have shown some sympathy for this worldview, and those tend to be the same justices that favor liberal access to the courts, a broad scope of federal regulatory power, and generous interpretations of environmental regulatory authority. And you have some other justices who have shown resistance to this environmentalist worldview, and those tend to be justices that have different views on the issues that I just mentioned. Against the claims of environmentalists, these justices place judicial restraint, limited federal power, and narrow constructions of regulatory authority. Now, I don't mean to suggest, and I don't suggest, that justices in this latter category that I've mentioned are somehow anti-environment. They don't wish environmental harm. Their resistance to environmentalism is motivated, I think, mostly by fear of the consequences of the environmentalist vision for individual autonomy and economic freedom. Now, these opposing views are manifest in Massachusetts v. EPA. I don't know whether you've had a chance to read the opinion, but you take the first page of the opinion just smacks you in the face. It starts off in striking fashion with this assertion: respected scientists, that's in quotes, believe that the rise in global temperatures is related to a significant increase in carbon dioxide concentrations in the atmosphere. That's the factual premise for the entire rest of the opinion. The court then quotes environmental petitioners' claim that global warming is the most pressing environmental problem of our time. The prominent placement of that quote so early in the opinion leaves little doubt that the court agrees with it, and the rest of the opinion bears out that implication. So if we assume that the court uses the first page of its opinion to tell us what is most important about the case, the most important things in this case are that anthropogenic climate change is real and that it is very serious. Now, in their dissents, both Chief Justice Roberts and Justice Scalia note the court's sense of urgency. They're careful not to say the court is alarmist. Their point instead is that the court's assessment of the risks, whatever they are, should have no influence on its decision. So even if climate change were a crisis, indeed, even if it were the most pressing environmental problem of our time, responding to it is the job of the politically accountable branches, not the courts. Thus, against the force of environmental urgency, the dissenters would place the barrier of institutional constraint. The outcome here, of course, would be no regulation. We can trace the influence of these competing views more specifically in the justices' positions on the three issues decided by the court. Specifically, the issues were standing, the scope of EPA's regulatory authority, and the appropriateness of EPA's decision not to regulate. So let's take standing first. The standing inquiry focuses on the nature of the injury necessary to invoke the judicial power under Article 3. Larry Walker has taught me the basic elements of the standing inquiry. There are three: injury, causation, and redressability. Got those down, Larry, I think, by now. The injury, we know, must be concrete and particularized and actual or imminent. The injury must be causally related to the legal violation complained of. and the relief requested must be capable of redressing the injury. Now, in his opinion for the court, Justice Stevens goes on at length about the particular merits of standing for Massachusetts as a sovereign state, and I'm not going to get into that. I hope you're not disappointed. I'm instead going to focus on the court's assessment of Massachusetts standing under the traditional three-part standing test. Massachusetts' argument for standing was based on a claim of systemic injury. And the success of that argument really depended on two things. First, the court's readiness to assume injury from human disturbance of a vast and complex system, the Earth's climate system. And second, the court's willingness to accept as significant climate effects that could not easily be quantified and might even be small, relatively small, within the context of the system as a whole. In short, standing in this case depended on a view of the facts consistent with the ecological model, and that is the view that the court embraced in its opinion. So you see Justice Stevens fashioning an extended chain of causation that goes something like this. Domestic motor vehicles emit greenhouse gases. Increased world greenhouse gas emissions have led to a heightened greenhouse effect, which has led to a global temperature rise, which has led to a sea level rise, which has led to a loss of Massachusetts coastline. EPA's failure to regulate greenhouse gas emissions from automobiles contributes to this loss. A correction of that failure will moderate the loss. Hence, injury, causation, and redressability. I'm not sure that Larry will be satisfied with that, but that's what the court has to offer on the question. It doesn't matter to Justice Stevens that the causal chain is lengthy and complex, or that specific impacts are relatively small or difficult to measure. His analysis accepts the notion that systemic injuries are just as real and serious, indeed more serious, than the discrete injuries that have traditionally supported standing. Now, Roberts' dissent on this issue argues that the court uses, and I'm quoting now, the dire nature of global warming itself as a bootstrap for finding causation and redressability. And his main object here is to deconstruct the court's causation story. So he says domestic automobile emissions are a minuscule part of global greenhouse gas emissions. The linkage between those emissions and Massachusetts coastal loss is fraught with complexity, far too speculative to establish causation, and far too speculative to make it likely that Massachusetts loss will be redressed by any auto emission standards EPA might impose. Now in this, Justice Roberts insists that he's not debating the scientific case for climate change or doubting its seriousness. He is simply taking Article 3 seriously and applying those standing requirements to keep the courts out of policy and to maintain the tripartite allocation of power. But by pulling apart the several elements of the causal chain and demanding proof for each, his analysis necessarily rejects the environmentalist presumptions of fragility, radiating harm, and serious consequence. We see a similar pattern on the merits issues. These two issues are EPA's authority to regulate and its determination not to regulate at this time. Both of these issues turn on the degree of discretion that the court is willing to grant the agency. The justices' different views on that question are framed by their sense of urgency about climate change and also by their concept of the role that that urgency should play or should not play in the court's deliberations. The court's opinion sharply limits EPA's discretion in dealing, or as the case might be, not dealing with climate change. First, it holds that greenhouse gas emissions clearly fall within the statute's ample definition of air pollutant. Quote, the statute embraces all airborne compounds of any stripe. Second, the court limits EPA's latitude to postpone regulation. Here, the court says, the EPA has to determine either